3, 2, 1, start. Learned Senior Counsel for the appellant vehemently contended that the High Court had patently erred in law in dismissing the writ petition as barred by res judicata. Stop. He took us to the relevant pleadings of the parties. The judgment of this court relied upon the relevant documents for submitting that in the appeal there was no occasion for the appellant to raise the inter se dispute between the contesting respondents, nor has the court adjudicated upon the present grievance of the appellant that assessment of its need by the committee as accepted by the central government was erroneous and an underestimate. Stop. That there was no express decision of this court on this aspect, nor was the appellant required to put forward this contention earlier. Stop. Hence, neither res judicata nor constructive res judicata would apply to the facts of the present case. Stop. He alternatively submitted that in any case the High Court could have held that the present grievance was premature as the appellant's earlier application for grant of mining lease, which was dismissed as premature by the state government, was pending scrutiny in revision before the central government, and hence this issue could have been kept open. Para. Learned Senior Counsel appearing for respondent on the other hand submitted that the appellant itself invited the committee to assess its needs for chrome ore and also invited the central government not only to accept the said assessment but also to exercise powers under Rule 59 for dispensing with the procedure under Rule 59 of the rules. Stop. That when the question of legality of the order of the central government was being considered by this court in the appeal, the appellant as respondent therein did not think it fit to challenge the assessment of its need by the committee as accepted by the central government. Stop. Thus, at least on the principle of constructive res judicata, if not actual res judicata, the appellant's present grievance is barred. Stop. It is also barred on the principle of estoppel and acquiescence. Stop. In this connection, invited our attention to relevant provisions of the MMRD Act and submitted that the central government's order was perfectly justified and binding on all parties, especially when it was wholly approved by this court. Para. Learned Additional Solicitor General appearing for respondent submitted that the committee was appointed by the central government in the light of the directions issued by the High Court in the writ petition stop that the central government's order of 17th August 1995 was merely recommendatory in nature and it was for the state government to pass appropriate orders stop. ये थे 428 वर्ड्स